Again, it's great to see everybody. Slightly different lineup today. Julian, welcome.
Thanks for being here.
I don't know how you got in the middle, mate, but we'll find out the relevance of
we'll
that later. We'll see. Lewis,
thank you.
Thanks for you. Look, we're going to do a kind of wrap up, and unlike most of our sessions this year, which have been informative and educational, where we've sort of thrown up lots of slides, we're going to spend most of the day talking. I think we've agreed to do the wrap up in 3 parts. We're going to talk about what's happened and what we think is really important, and interesting enough, we've all got very different ideas about what was the most important thing during the last year. We're going to talk about what hasn't happened, because I think sometimes that's more interesting in a way. And then we're going to give some predictions for what's coming up next year. We'll try and do 20 minutes. We've got quite a few questions coming through, many of them on the first topic that I'm going to actually throw to you, Lewis. So why don't we kick off, Lewis? What do you think is one of the most important things that's happened in the last 12 months that we need to think about?
Thanks, Nigel, and hi, everyone. There's obviously a lot to choose from, and I thought the one that I would pick, whether it's the most important or not, I don't know, but it's certainly worth talking about, and that is the introduction of the labour hire arrangement orders. And the reason that I think it is noteworthy is, unlike other areas of the reforms that we might talk about, the labour hire regulation order scheme has seen a fair bit of take-up, and it's interesting to see what that take-up's been. So just by way of summary, under the closing loopholes legislation, there was a new regime introduced whereby a employee organisation, effectively a union, could apply to the Fair Work Commission for an order that required a labour hire company to pay...
Not the labour hire company, sorry, the cost of it ultimately is borne by the host though.
The labour hire company. The labour hire company...
That'll be passed through.
Yes, okay.
We'll come to that. That's an important issue.
The labour hire company will have to pay its employees the same rate of pay as the rate of pay that employees doing similar work or the same work at the host employer are doing under an enterprise agreement. So if you have a host employer, whether they be a mine, whether they be a passenger transport service, whatever they are, they have some of their employees doing work, and then labour hire employees, those labour hire employees now need to be paid the same rate as the host employees if they're doing the same work and if this order's being made. And
so you and I could be working for the company, we're on an enterprise agreement, we're getting $35 an hour. I've got young Julian here from the labour hire company getting 27. The argument is he's doing the same work as us. Most employers will say he's not actually doing the same work, but that's the principle of it. The union come along and say Julian should actually get paid the same as you guys are getting paid.
Young Julian has a question. Labour hire regulation order. Surely there's this pithier way of saying that. What are we talking about here?
Same job, same pay.
That's the one. There we go.
But there's been a lot of applications.
Yeah. So the reason I bring it up, so that was effectively the scheme introduced, and the only way you get out of this. In terms of the material exemption is if you're a service provider. Rather than simply providing bodies or labour, you say, no, I'm providing a holistic service, an entirely outsourced service. If you can establish that exemption, you're outside the scheme.
So genuine service contracting, providing specialist activity, managing its own workers, etc. More likely than not, don't panic.
If you can meet that test.
If you can meet that test. Just simply renting the body to work alongside the host's employees, that's where the problem lies.
And what we've seen is we have seen a number of applications to date, even though the law's only commenced, or the orders can only commence from 1 November this year. We've already seen 6, 7, 8 applications. And in the vast majority, the employers have consented to the applications ultimately. They have not contested them. There is one currently being contested by BHP. If you put that aside, the majority of the cases have not only gone through by consent, but we've seen quite material uplifts in pay. So we're talking 20%, 30%, in some cases 40% increase in labour hire rates of pay compared to what the labour hire employees were earning previously. And the reason I raise it is because, unlike some of the other areas we might talk about, this is really an area of the government reforms where whatever you may think of them, it does appear to be achieving the government's intended purpose. The government had identified that in its
Whether or
view,
not you agree with the purpose, it's actually achieving their purpose.
that's right. And whether the government, the government had identified in its view that there was labour hire employees out there earning less than employees doing what the government considered to be the same work. And it had this concern that it didn't think that was fair and reasonable, is how they've worded it in the legislation. And by and large, we've seen employers effectively accepting the increase without a lot of resistance. And we're likely to see more of that as the unions organise themselves, because it's only the 12th of November. The laws can only commence or have application from the 1st of November. We've already had 7 or 8 kick into place.
There's probably 3 things I'd add to that, because I think it's a good one. It's a really good one. I think if you think about a lot of our clients, they were very concerned about same job, same pay a year and a half ago. We're doing a lot of work for them. Number one, by its nature, it's going to be in unionised sectors.
Yes.
If you're in a non-unionised sector, I think this is going to take a very long time having any implication for you. That's number one. I think the other thing that's quite interesting yet is when I talk to companies, I don't see any companies proactively doing this. They're not sorting it out now themselves. They're waiting. And probably the third thing I would say is I'm not sure this will necessarily mean they'll stop using labour hire and they'll start to self-employ casual employees and the like, in part because of what's gone on with casual employment. So I think this is probably for business a cost issue more than anything else, rather than a restructuring of the workforce issue. But yeah, you're right. It's sort of like a hot cat. It's like it's just gone off. It's gone off with a bang, hasn't it? You're absolutely right. Mostly in mining.
Not just mining. I mean, we've seen it in airlines. So Qantas has already rolled on one of the applications for it, and we're seeing it in other places now as well. So it started in mining, and that's where the first contested order is going to be. But it's much broader than that, is what we're seeing at the moment.
Are you declaring loophole closed? Is that what you're declaring? Because, I mean, it sounds like that's what you're declaring.
As I said, I think...
He's not conceding it's
the
a loophole in the first place.
I think the government, it is one of the measures that has, you would say, has gone closest to achieving effectively what the government had tried to do. We're going to talk about other areas where that hasn't necessarily been the case, but certainly it's having an effect.
The other thing is, I think the same job, same pay narrative and that tagline had this, it did create a lot of fear, a lot of concern, a lot of misinformation. And I think one of the things that I think we've all said throughout the journey is this is not going to apply to everyone, and pretty much if this is going to happen to you, you basically know it's coming. You have set up in a way where you are...
Having moved to an application process rather than a general rule and principle, that allowed that to be the case.
Correct.
Yeah.
As well as the fact that most businesses are not set up in a way where this would necessarily apply or necessarily be a useful thing to do.
You have to put your hand out to the part of the employer movement that lobbied very hard on this issue.
Yeah, and the other thing is the service exemption. Don't forget, if you are one of those employers that says, well, I'm not sure I'm using labour hire, what I think I'm doing is I'm providing a wholly outsourced service where I provide an entire solution to business, you can hold your ground, and that is yet to be tested. Where people have rolled is where they know they've got nothing. Okay. And we'll wait to see. And if you are in that service exemption, you might have a very different scenario.
I'm going to let you go next.
For what happened this year?
What happened this year? What's the big one you want to talk about?
So I want to talk about the positive duty. I have spoken to...
I'm sure he's going to say the CFMU, but we'll come back to that.
We'll talk about the CFMU later. I have spoken to thousands of employees, and over the last...
He's not actually lying with that.
Let's say 2 years.
You've been on the hustings, haven't you?
Correct. So the positive duty to take a reasonable and proportionate measures to eliminate sexual harassment, sex discrimination, hostile workplace environments and the like, came in sort of end of 2002, 2022. We had this sort of informative year, 2023, and 2024 is where the rubber's hit the road. The Human Rights Commission has got enforcement powers, and basically businesses are getting serious about educating their staff about what the positive duty is, taking steps to satisfy the positive duty. And as if you haven't spoken to me or one of my excellent colleagues,
Alana Rafter would be a good example.
Tamsin Lawrence is another.
Yep.
You will know that you don't need a problem, you don't need a complaint, you don't need an issue, you don't need an environment to be in breach of the positive duty. All you need to have done is nothing. So if, looking straight down the camera, if out there you are still 4 in 10 employers, this was a survey done by Our Voice in the fortnight ago, 4 in 10 employers do not know that the positive duty exists. If you're in that 4 in 10 and you haven't got a policy, if you haven't got an updated grievance procedure, if you haven't trained your employees, if your board don't know what a positive duty is, if you're not keeping records, if you haven't done a risk assessment, you're likely in breach. And things are moving in this space. Safe Work New South Wales, they've just doubled the amount of inspectors they have specifically assigned for this area. The Safe Work New South Wales have got their first conviction in the space. And it's all happened in 2024. It will continue to happen in 2025.
Did the conviction give rise to penalty?
Yep, so it's 300 grand penalty and 140,000 in costs. I think Marist Youth Care, so that's all on the record. That's in the sort of disability care space. So again, case is a great example. This is not just about employees making sexual harassment complaints about other employees who do or say
this is about what the employer's proactively doing before that even arises.
Correct.
And I think another example of legislation that's really starting to hit its mark, for all those out there trying to understand how to grapple with this, it's really 20 years ago, the WHS regime came in and boards started to get serious about WHS, and they started to understand we need to take due diligence, we need to be proactive in this space. That's what this law is aimed at achieving. Positive duty is aimed at adopting a WHS style mentality to harassment and other inappropriate discriminatory behaviours in the workplace, and it's working. And I think boards are starting to take notice, and I think it will continue to succeed.
The reality is they could have picked anything. They could have picked racial discrimination, they could have picked political persuasion, union membership.
You never mention age.
No, I don't. Young Julian doesn't mention age.
Julian never mentioned
They
age.
picked sexual harassment and the other related behaviours to elevate it above all those other things, as you say, to put it in that safety space. And you can see the faces sort of click over when we're talking, particularly to safety managers about this. They say, I know what a risk assessment is. I can do this. I just need to apply it to something that I haven't applied it to. And there's a lot of movement in the space. I think it'll continue.
So you've spoken to a lot of directors, a lot of board members in the last 12 months in particular. What's your sense of how they've received this?
The vast majority at the executive level take it very seriously, are on board, want to be part of the journey, and want to make their businesses a safer place. Funnily enough, you can tell the people in the crowd, and they often have their arms crossed, and they often have a bit of a grimace on their face, and they're thinking to themselves, why is this suit talking to me about this and telling me how to behave? I just want to get on with my job. And I always say the same thing, it's the law. This is what you have to do. And not only is it a law, you'll have a better workplace if people get on board with this.
So when you're out there, it seems to me that you're quite well received.
Correct.
It's not, oh God, it's one more thing we have to do. I get a sense there's a genuine engagement in this.
As well as the fact it doesn't hurt my appearances at these various things are in a context where every other day there's a story in the paper about what's happening at a particular, in an industry or an employer. People care.
In a pub?
That people care about this,
Yeah.
and people know that we are all on a journey to changing workplace behaviour.
Improve the society.
Exactly, taking it more seriously. So it's good.
Okay. Well,
What's yours?
what's mine?
Yeah.
I got about 5, so I'm not sure where I'd start. Look, to be really fair, I suppose I'm going to start with multi-employer bargaining. I won't talk about all of it, but as obviously as I think we spent so much time in the last 18 months talking about multi-employer bargaining. But the bargaining world sort of changed dramatically through the reforms. We've got what we might call standard enterprise-based bargaining continuing, largely as it's historically continued. There's some changes around the edges, let's use that phrase, but largely continuing. We've got 2 forms of multi-employer bargaining, neither applicable to the building and construction industry. One is called supported bargaining, one is single interest authorisation bargaining. I might leave the second one to you, because I know you want to talk about it in a different context. Obviously, we've just spent the last 18 months leading the childcare supported bargaining process. We're kind of at the rocky end at the moment. I reviewed the draft agreement yesterday and sent it back to the unions. I won't breach any confidence at this stage, but we're getting very close to the end of it. I suppose the thing, it's probably more about reflecting on the process and what that means for multi-employer bargaining generally. So if you reflect on that process, I'd say these things. First of all, everybody who participated in this process agreed to participate. They engaged to do it, which might not always be the case, right? It probably took about 6 months to engage with the unions involved. I'll come back to those in a minute, about who's coming along for the journey, filing the authorisation application to begin with. And I get it was the first one, but even so, it was quite a logistical exercise. We then had basically three employer groups at the table, for want of a way of putting it. One not-for-profit, one for-profit, one very, very big for-profit, and we had three unions. When you actually look at that, and again, remembering they all agreed to be there, what intrigued me about the processes was it didn't take very long for natural differences to emerge. And what I mean by that is that the way the various parties approached it were different in terms of their bargaining approach. Some of the unions had obviously gone to transactional bargaining school, and you make a lot of claims, and others hadn't. So that was really interesting. And then quite clearly, you had three employer groups who didn't always have the same interests. So you had a lot of situations where some of the employers would say, well, look, this yes or no, or look, I'll hang back because they're worried about this, but I'm not, but I don't want to upset them. Or what I'm trying to say is it ain't an easy process, and that's with people who wanted to be there. I can only imagine what multi-employer bargaining is going to be like if the employers don't want to be there. They don't want to be in the room together. They haven't been in the room together for the last 25 years. You've probably got the General Counsel still running around going, isn't there a competition law rule that stops this? Our process was really challenging. It was entered into with a great deal of good spirit, but we wanted to be there, but it was still very, very difficult. Imagine if you didn't want to be there. So this anxiety of the walls are going to fall down quickly, I don't think is going to happen. But I do think now everybody understands that one of the strategic considerations in your business is, are you going to embrace multi-employer bargaining? Are you going to defend against it? Or are you going to hide? And I've been going around the country now for the last year talking to so many companies about those strategic propositions.
And I think, Nigel, your point about how difficult it has been is an interesting one for those listening, because, as you say, it hasn't really kicked off in the single interest phase for most businesses out there, and it's going to continue to reinforce their fears about how difficult it might be. But I suppose that's why what we are seeing is a bit of an uptick in normal single enterprise agreements, because what we have seen from a strategic perspective is people who wouldn't ordinarily bargain or who've let bargaining lapse quickly dive back in because they want to insulate themselves from this process that you're talking about. Yeah, it sounds like you're saying that that's the right call. Because
I think that's a really good take-up, because we've got a lot of clients who've got lapsed agreements because culturally they could afford for the agreement to lapse. That is probably low union involvement in their business, progressive culture, it's probably highly participative workforce, some self-managed employees, so really good culture, low union involvement. They probably could culturally allow their agreement to lapse and work with an expired agreement, sometimes quite an old agreement.
Yep.
They now have to actually stop and prop and say, well, that's a cultural decision, but I'm actually, while that's happening, can I hide? Because without an agreement that's in its nominal term, I'm technically potentially exposed to being roped in to multi-employer bargaining in some way, or a multi-employer agreement. So, yeah, it's been...
But that's part of the design, isn't it?
I think the design of the scheme was to try and force as many employers onto enterprise agreements. And then you take Lewis's point, which is a lot of employers have remade old agreements so that they are current. And we've got quite a few people who haven't bargained before, who for good reason, and I always say to most people, please have a damn good reason to do it, have moved into bargaining for the first time. So, yeah, I mean, that's been a massive uptick in terms of the workload we've got.
You know, if you're painting multi-employer bargaining as the boogeyman, you're going to run away from the boogeyman, and that may well be into just stock standard enterprise bargaining. And surely that must have happened.
Well, I think the answer is it has. But I would say this, you would do that with great care, because there's been quite a few people around just going, get an enterprise agreement, get an enterprise agreement. And as you know, I talk as many people out of them as I do talk them into them.
Yeah.
Because you've got to understand the cultural environment you're in, you've got to understand the industrial environment you're in. It's got to work for you.
Yeah.
Not just as a device against multi-employer bargaining. It's got to work for you because it's so bloody hard to get out of now for the long term in your business. And that's all about the architecture of agreements and all sorts of things. But yeah, that's probably the one that I probably picked up on the most this year. Why don't we move on to what we haven't seen? Jules, do you want to have a crack? Do you want to go first?
I don't think the change to the casual employment definition, and I appreciate this is all very new, but I don't think the sky's fallen in yet, and I'm not sure that it will.
Yet.
There is a lot of noise about how complex the casual employment definition is. I'm not sure it's that complex. There is a lot of fear that we have these swarms of currently casual employees who are going to magically turn into permanent employees with a magic wand overnight. That's not going to happen.
So I want to see if you can do this without a slide, because you've got one of the best slides on this I've ever seen. But let's go back to the audience again. What are the new rules?
Well, the new rules basically are that the contract is no longer king or queen. So you cannot just look at a contract and say, well, this person's a casual because this sort of suggests it's a casual. You need to talk. You need to go to the real substance of the engagement.
Contract's still relevant though, but it's not determinative.
Well, it'll be probably determinative at the start of the engagement because there's nothing else. But there is a long list of different criteria that you would assess whether someone's a casual or not. Their ability to refuse shifts, to accept shifts, whether there are any other employees doing that kind of work as a permanent, and there's a whole list of them. The point though is the casual does not become a permanent until they ask to be a permanent.
So they don't mythically morph.
It is a conversion. It's a conversion process, and as we learnt 10 long years ago in the casual and part-time case,
was that 10 years ago?
Well, close enough. there are a lot of casuals who, shock horror, like being casuals.
They were great witnesses for the union, weren't they? No, they were great witnesses for us.
A lot of casual employees like getting 25% extra. A lot of casual employees like the flexibility. A lot of casual employees will not ask to become permanents, and so I don't see the world falling in. I don't. Again, all of this is it's potentially to come, obviously, but the fear. If I said what didn't happen, I think people are calm about casuals.
And Julian, I think your point and what's critical about this piece is if you get the engagement right on commencement. So what that means is you do have the right contract in place to begin with. You have a very clear, the key functions about being able to refuse shifts, the payment of the loading and what it's for. If you get all of that right and you can demonstrate that on commencement they were a casual, then irrespective of what happens after that moment, you require them to officially apply for conversion and either be granted or refused and have some dispute before they morph over. And what that means is you have what all employers crave, which is certainty. And so what you do need to do is ensure that your documentation is in order for that initial engagement, and we're obviously happy to help with that. But if it is in order, then all your headaches go away, because just like the labour hire arrangement orders we talked about before, if they're going to change or there's a prospect of that, you're going to get a big notification. And then you can take advice and you can deal with it as you need. So I agree with you, Jules, entirely.
The other thing that hasn't happened, just if I can add in an extra bit, is we have run a number of Fair Work Commission cases this year. We had right to disconnect, we had...
I'll come to that, that's one I want to pick up.
We had delegates' rights, we had a whole award review. I would say it's been relatively...
And the job security part of the award review was a scary part.
Yes, it was scary at the time. Are you still
No, because I was optimistic that good sense would prevail, and that some of the claims the ACTU were advancing about basically making the workplace entirely rigid and almost inoperable for employers to actually deploy labour would fail. And guess what? They failed.
I think if I could sum up those kind of cases from the Fair Work Commission this year, there's been a fair bit of restraint, or at least to the extent that the union have advanced claims which would massively increase conditions protections that have been brought in through legislative change. They've largely fallen on deaf ears. So that's something that didn't happen.
So, but would you agree? Okay, so the sky hasn't fallen in, but the cost of doing business has gone up. Would you agree with that?
Not with casuals, I wouldn't say. I mean,
no. In a broader sense, cost of business is.
Well, obviously.
Yeah, obviously. Yeah.
You only have to look at how many legislative changes have been pushed through. I guess my point is that the Fair Work Commission's specific reviews or dealing with certain claims so far hasn't necessarily, in my view, contributed to that. But there's been a lot of legislative change.
So we get a lot of questions on casuals. Some of them very, very particular, but. Just talk about the casual statement, because the one thing I've noticed as I've gone around the country in the last year, the fact that people have to provide the casual statement, there's different rules for small business and big business. I don't think people are understanding that. So
the casual information statement now needs to be provided, and for a larger business, it's on commencement. It's then again at 6 months. It's then again at 12 months. It's then again at 24 months.
So the reason why I let Lewis answer that question is because I don't think I would be believed if I said that. But it's extraordinary.
That's extremely onerous.
Send.
And the difference, and I unless Jules is going to jump in and get the exact, is that for a small business, one or two of those drop out.
So
you've still got commencement. I think it's commencement, and there might be a 12-month. Whereas large business, you've got this kind of commencement, 6 months, 12 months, 24 months. But there is a good element out of all of this. The casual information statement is in some respects the price paid to now not have to write to employees. Let's not forget, because everyone wants to whinge about these reforms, let's not forget that it was the previous government that introduced a horrific regime, which was that at 6 months you needed to write to the employees and inform them that they had a right to convert, and if you had reasonable business grounds, you had to refuse, you had to then outline that. All of that's been taken away. We no longer need to write to employees to inform them about rights to convert at various points. We've jettisoned all of that. There is a right of election to convert, but you just have to give this information statement. So it is much easier. We're not doing lots of bespoke drafting of different letters.
We're not doing audits.
You're not doing audits as to who's meant to get a statement and not. So I think that has been a good development. We're just in a painful period at the moment of transition that you're actually still got to comply with both regimes until February next year. So painfully, if you currently have casuals, you still need to write to them and inform them that they do have a right to convert on their 12-month anniversary under the old regime until 26th of February next year. On 26th of February, we fully transition over to the information statement regime, whereby you no longer need to write people and inform them of the right to convert. So you actually got to comply with both regimes till 26th Feb next year, which is painful.
So understand the rule. Make sure you're sending out the casual information statement when you're meant to. But for the most part, it's now in the hands of the casual employee. Those who are genuine casual and want to be will probably never make the request. If you're actually having a lend of them and working them 38 hours a week every week, they might very well choose to stay casual, or they might actually make the request. And then, of course, there's various defences in terms of whether or not you say no or yes. Jules, the defences?
I wouldn't put my faith in many of the defences, quite frankly. I think, and I say this trying to provide some insight, if you satisfy the definition of a casual, I just don't see many employers successfully defending
definition of a full-time employee,
correct,
or a part-time employee,
correct, or no longer satisfying the definition of a casual.
Yeah.
So I think it's one of those things where the benefit is in that, yes, you don't have to audit. Yes, you just have to wait, and you know. To be honest, I think most employers don't want to fight. If most employers who have a casual who want to become a permanent, they're happy. A lot of employers are trying to convince their casual employees to become permanent.
Well, when I was in corporate life, we spent a lot of time trying to do that.
Correct.
Yeah, it did. Well, they're yours?
That's me. I was
That's
wondering
you,
whether
that's
you're going to Lewis next.
No, I'm going to steal the show.
Please, go.
I'm going to steal the show.
Go.
Which one would I pick? What didn't happen? I'm going to do this in a strange way. And in particular, I was in the northern New South Wales a couple of weeks ago doing some work with the New South Wales Small Business Commissioner, and I'm going to talk about right to disconnect. And what I mean by what hasn't happened, I think what hasn't happened is I don't think people have understood what it is. And I'm still shocked that they still don't understand what it is. So just to be completely clear, right to disconnect rules came in 26 August 24, but for small businesses it's 26 August 25. But all modern awards were varied at or about, I'm getting it wrong now, sometime in July, a couple of months ago, for right to disconnect course. What is it, what isn't it? So I've used the phrase consistently when I talk to people. It is a right in certain circumstances for your employees to ignore your communications. It does not prevent you emailing them, it doesn't prevent you ringing them, it doesn't prevent you texting them, it doesn't prevent you doing anything during working hours. Normal rules apply. I mean, if you're stalking one of your employees, that might be a slightly different issue, but hopefully you're not. It's really about what happens after work, and the general proposition is that in certain circumstances, it might be reasonable for the employee to ignore your communication and not reply. I'm amazed that so many employers haven't understood that, and so many employers still think I'm legally prohibited from actually sending the communication in the first place. And that's kind of shocked me a little bit. And I think that part of the problem is in the name. Is that when you go on social media and you see the name, the notion of a right to disconnect is it's the right to be left alone. It's actually not a right to be left alone. It's a right in very quite specific circumstances to ignore.
Or a right to not respond.
Or not to respond is probably a politer way of putting it. And of course, there's, as Lewis, as I'm going to put to you, there are certain tests that are applied to whether or not it's reasonable or unreasonable to respond or not, how much you get paid, what the nature of your job is, what your circumstances are. There's a whole raft of tests, and we've consistently said now for the last year to just about everybody, think about the moments where you do contact employees after hours, or where clients or customers contact employees after hours, and use the pub test. Do you think it's reasonable? I've sat down with a lot of people over the last 12 months and actually done that exercise. And 100% of cases often are, very reasonable. There'll be the odd case where you go, gee, I'm not sure about that one. That's kind of interesting. Perhaps we need to think more about whether or not we should actually be doing that in the first place. But, a lot of people thought the world was going to come to end. I won't be able to tell people their shift is changing. I won't be able to tell people I need them to come in on Saturday at 2 o'clock in the afternoon to the cafe rather than 3. All of that mystique's hopefully now evaporated. Normality has come into it. But my thing about what hasn't happened is people haven't kind of understood what it was.
But you're talking about the statutory right and currently what's in the awards. You're not talking about what someone might agree to in an enterprise agreement.
Sure. Oh yeah, I agree with that.
You're also not talking about what potentially is going to come through union claims in the modern awards to vary, particularly in certain industries.
Which we will defend vigorously.
So and I think your comment about public perception about what it is, it applies not only to employers but also to employees. If employees
I'm talking about my friends as well.
Maybe your staff. If you unless
they have no rights.
Unless you've engaged in some form of, because there was a decent debate we had when this was happening as to how you actually reach out to employees, or how an employer should reach out to their employees. Do they go out on the front foot and tell everyone you've got this right to disconnect? The danger of that obviously is that they misinterpret it and think, okay, well fine, 5 PM's over, I'm turning the phone off, walking away and forgetting about it.
Well, given working from home, 5 PM most people might have turned off anyway. But
let's not get into that. So it's been this balancing act between employers trying to talk to their employees and educating employees about what this right actually is. But we will definitely see, won't we, Nigel, more business, organisation specific, tailored right to disconnect, either enterprise agreement clauses or potentially award clauses, which maybe do have prohibitions on them.
Yeah, they're two good pickups, and probably I'd respond this way. Number one, I'd say, and as you know, I spend probably at least half my life in bargaining. I actually haven't seen that many claims emerge at the moment, and I think there's a reason for that. I think they'll come.
Yep.
I think there's a reason for that, which is given the inflation spike and wage outcomes in the last 4 years, most of the conversation really is about, money, and a lot of the conversation is about, I really understand my place in the world has really gone backwards in the last 4 or 5 years in terms of my wages power. So most of the focus at the moment really is on money and inflation, past and future. So I actually haven't seen a lot of kind of out there claims. I'll tell you the one thing I have seen that's a bit scary, and I'll say this with great care, given that having worked in human resources before and given that most of our clients are in HR. I've seen a lot of HR people try and be progressive about this, and they're actually introducing something that's way more onerous on their business than the legislation. Now, if culturally that's a good thing to do for your business, then I'm pleased for you. But just be very careful you understand what you're doing and you don't actually create a rod for your own back. So I've had 1 or 2 clients come to me and go, we're thinking of introducing this policy. And I said, you do appreciate what this policy might mean for you in the long run? And they've gone, we hadn't thought about
I think that this is the thing about the right to disconnect. It's a yardstick to commence a narrative and a journey that is a 15-year journey. Yeah. And whether we end up at the ultimate destination...
Like France.
That's right. Whether we end up at the destination that was the design of those that push for this.
Remember, it was a Greens thing.
There was a big push from the Greens in relation to this. So whether we end up closer to that end destination or whether this gets jettisoned, that's an answer you can't give for 15 years. The thing is, they've started that, but in its current form, I agree with you both, it's quite easy to comply with. It's probably not going to give rise to real practical impediments to running a business. And the reality is, if you do really need someone to respond, put aside a safety critical incident or an emergency that people will respond to anyway. And that's the other thing to bear in mind. Employees aren't going to refuse to respond about an emergency or a safety matter anyway. We're really also talking about shift changes and
the on-call roster.
Things like that. If you are going to have a dispute about that, I think you'll find the Fair Work Commission itself is going to be quite reasonable and accepting of the fact that certain industries in particular require changes at last minute. You can't always know that you need to put on extra staff in a pub 3 weeks out. You can't always know that a tugboat operation or a freight rail operation or a bus operation needs new people the next day. And the Commission understands that. And so I think you'll find in disputes, there will eventually be a dispute about this to do with shift changes and things like that. I think we'll end up at a pretty reasonable landing point. So there's nothing to be too concerned about.
I think the interesting lesson about right to disconnect, ironically, is probably the political lesson. It's not actually how it ended up being, but some of the more troublesome stuff that went through in the reform round actually came from the Greens, not the ALP. So the changes to intractable bargaining, the right to disconnect, all of this is coming out of Greens land.
This is the frustration in relation to the reforms. Why are we talking? This is the whole problem, and we're seeing this in the political spectrum. We're seeing this news. Everyone's talking about right to disconnect because it's this sexy topic. And what we're saying is this is not really a big deal. And what we're not talking about is intractable bargaining forms. What we're not talking about are these other things that have had much more substantive impact, and one of which I might come to in a second. But because they've got a catchy phrase and it's something the press are interested in, there'll be an article on right to disconnect tomorrow. Will there be an article on the intractable bargaining changes?
I don't think many journalists understand what bargaining is about, let alone intractable bargaining.
And so you'll hear more about it, but I think you've heard from all of us that most businesses, it shouldn't be a concern. So I can go to my concern.
You go to your concern. So what hasn't happened, mate?
I'm going to go back to casuals. Not what Julian was talking about, though.
Are you ready for this? This is new to me.
It's his favourite.
This is his favourite topic? Okay.
The casual conundrum.
This is unfortunately somewhat...
somewhat...
I'm already being laughed at.
The bugbear.
This is somewhat technical for a webcast, but it is vitally important. For anyone involved in bargaining, it will determine whether your EA succeeds or fails, and it's a mess. And what it is determining whether a casual has a right to vote on an enterprise agreement or not. And based on the current state of the case law, if Nigel's asked us a lot for the test today. There's a bit of a quiz.
We've got a view of the rule, and then we've got a house rule.
But the problem is there is no coherent answer right now.
What we normally say to a client is, if you want to be absolutely black and white about this, casuals actually got to be engaged when the vote starts. We will say, if you want to take a slightly more liberal view, it's during the voting period, and you might even squeeze in the access period as well, but everything outside of that, forget about it. And more likely than not, unless you've got a massive casual voting cohort, you'll be fine. If the casual cohort could swing the vote, I'd probably say go for the black and white view.
But the problem is, even in black and white, we now have commission cases all over the shop.
I know.
So if a casual's not working during the access period, or during the voting period, but are rostered thereafter, they may well still have a right to vote.
Yeah, I know.
And the question, the problem with all of this is that there was an absolute opportunity for the government to reform this.
And 2 lines in the Act.
And it didn't matter which way they went. It didn't matter whether it was erred on including them or erred on excluding them. The point was you would have certainty as to who's in and who's out for the vote. And if you are conducting votes, you do need, the cases are evolving rapidly. There is a full bench decision from July this year that has for the first time indicated people not rostered during the access period or when they vote could well still have an entitlement to vote. There's a question about what's in their contract of employment. We've got numerous commission decisions determining whether a casual employee has an ability to vote or not, depending on what's in their contract. So there's 2 really things that I want to
be upset about.
Rant about. There's 2 things that one's a rant and one's a piece of information for our viewers. The rant is it's a complete mess, and the government should have fixed it and still needs to fix it.
You're not asking the ALP to make more reforms, are you, Lewis?
In this space, they can't go wrong, whatever they do, as long as it's more certain. But secondly, if you are going to vote, you need to speak to us for this reason. It is rapidly evolving who you can and who you don't.
You're right. The answer we gave 3 months ago might not be the answer.
That's right.
Today. You're right.
Well, the answer that the rule you applied 3 years ago when you did your last enterprise agreement is probably definitely not
the answer to that.
And moreover, it can actually really depend on what's in your contract with them. So you need to be very careful in this space. So that's what I say didn't happen.
And this desperate plea is you're looking down the camera. All these people are watching. You're talking to the government. You're not talking to the full bench. You're not talking to the federal court. You're asking Parliament to fix this.
Through the Australian Chamber, because we do act for the Chamber on occasion, or relatively regularly, we've actually put forward concerns that this is something that needs to be addressed. It hasn't been yet. If it's not going to be fixed legislatively, then there's going to be, at some point, some level of guidance required from a Fair Work full bench or the federal court.
I just realised that if we had a bottle of wine, this could be a 3-hour Joe Rogan podcast. So we need to be careful about time here. So did you have one more before we jump on?
I'll only deal with this in 30 seconds because we've actually ventilated a bit, which is Nigel's talked a lot about supported multi-enterprise bargaining. On the other side of it, you have single interest bargaining. So what that is a multi-agreement where various employers are bundled together, possibly against their will, on the basis that they have reasonably comparable businesses.
And common interests.
And common interests, and forced to bargain together. We haven't seen a lot of that. I think in part because of what Nigel's been talking about, it's very difficult to align everyone. It's difficult to identify who's going to be the target. I mean, we will see some more of it, you would assume, but it really hasn't taken off. And that's the kind of what hasn't happened. It's landed with a bit of a, what's the opposite of a thud?
No, dead cat bouncing, isn't it? It's dead cat bouncing.
It's landed like a...
But that's going to upset everybody who's got a cat, I imagine. But
surely you can think long term with that. But,
do you know the thing that I think most people misunderstood about enterprise agreements? That particularly people who've been bargaining for, like, I'm on version 10, version 15, and we've got a lot of clients who are like that.
Yes.
Right? They forget how much genuine ownership of that document there is in the workforce. Particularly if you're in a unionised place, more often than not, you might have a delegate or delegates who've been there for 15, 20 years. I mean, I deal with clients where I've known a delegate for 30 years, actually personally known a delegate for 30 years, and they've seen general managers come and go, come and go, come and go. The amount of ownership they have in their own enterprise agreement, to give that up actually, it's going to be a hell of a persuasive conversation to make them give it up. So I think that people have misunderstood the complexities of persuading employee cohorts to do it as well. I really do. But that's yours?
That's me. That's what hasn't happened.
So what's going to happen? What's going to happen? I'll leave mine for last. How about I'll go last.
I can do mine quickly.
Yep.
We're gonna hear a big junior rates case next year.
And please tell me you're going to win it.
We're on camera. We can't make any promises. The junior rates case is going to be a case that will seek to remove.
So you are running it, are you?
Yes,
Yeah,
Nigel.
okay,
Let's
good.
not have team meetings on camera. Junior rates is a case brought by the SDA. They are
So
seeking
shops, union, and retail.
correct retail, fast food, and pharmacy. The aim of this claim is to remove junior rates, which are discounted rates for people of certain younger ages, remove junior rates for people over the age of 18, and increase junior rates for people under the age of 18. So 16, 17-year-olds will get a bump to their pay.
But not evaporate the junior rates completely.
No, it doesn't draw a line through junior rates completely, but it does for anyone over the age of 18.
Because some industries have 19 and 20
19,
year olds.
20.
Correct.
I think they used to have 21, and 21
Correct.
got thrown out about 4 years ago.
Correct.
Yeah.
Correct. And so the point is, the argument is, well, if you're 18, you're old enough to vote and to drive, and you have cost of living pressures, so you should get adult rates.
Now,
Of course,
I'm the only one in the room with kids over the age of 18, so I'll be careful how I comment on this. But
so the flip side of all of this, as we all know,
so at a time when we're stopping people under the age of 16 having social media because it's not good for them, we're actually going to give people who are 16 and 17 much higher rates of pay. Because
well, see, I don't know if that will happen.
Okay.
Because
I hope it happens.
I think the point is that the reason why juniors are employed in fast food restaurants, in retail establishments, is because employers see the benefit, obviously, of the discounted rate, but see the opportunity to give a young person a go, to train them up. They've got no skills, to supervise them more, and yes, they derive some benefit from having some form of discount to the rate. I really do see an issue with making it a flat playing field, because if you have the opportunity to employ a 30-year-old person, or an opportunity to employ a 17-year-old person at pretty much the same rate, I don't think you're going to plump for the 17-year-old in as many times as you would now. Looking down the camera again, if anyone watching employs juniors in any of those industries, please give us a call. We represent you, interested in speaking to you, so that's going to happen. I think the right to disconnect for small businesses, which comes in, is going to be a complete mess for all the reasons that you've said. And we're also going to see the road transport jurisdiction of the Fair Work Commission really start happening next year. And us three, in fine bookstores everywhere, we've written a book, Owner Driver Law in Australia. This will be exciting and interesting for us. It's all
and
happening.
some of our very, very big clients.
Clients and friends.
And clients and friends.
It's going to be a brilliantly interesting 2025 on that front, and that's all I want to say.
Okay, all right. Do you want to go?
Happy to.
We haven't interrogated you on any of that, have we?
Oh, because it's all straightforward.
All right. I suppose the junior rates issue is the anxieties. This is the retail award sets a precedent that might flow through other awards.
Well, I mean,
and I actually do believe that if you kill the discount too much on a junior, there'll be a tipping point where the incentive for the employer to actually take an unskilled young person into the workforce.
Because it's a mutually beneficial
it'll go.
arrangement, right? And there's nothing wrong with reviewing them and to see if they're still current, and that's fine. But you need to recognise the mutual benefit and ensure it's all factored in. And you've really got two issues driving it, don't you? One is the appropriate rate for the very junior, 16, 17, and then there's the debate about the 20-year-old, and still, is there a mutually beneficial arrangement there that, and this will be the case we're going to put, about why it's still, there is benefit to having this rate and what it does, because I think we call these vestibule industries that are
particularly restaurants, cafes.
The first stepping stone into the workforce at large, and there's a whole heap of merit to ensuring there is a pathway, and that pathway is preserved effectively.
But you want to employ more young people, not less.
I'm with you.
So,
and particularly in areas where we've got youth unemployment running at 30, 35, 40%, and there are places in Australia where that's the case, and it's not unusual to see 25% of youth unemployment in socioeconomically depressed areas. These are the types of jobs they're going to get. Why make them harder to get?
Yep.
Lou?
So another case that we're going to have in the Fair Work Commission pertains to working from home. So the Commission's effectively kicked off a general review of award terms in the Clerks Award, an open slather review as to whether the award terms are appropriate for working from home. So we're going to see two different types of claims. We are pursuing, on behalf of employers, a variety of variations to ensure that the Clerks Award provisions are appropriate for working from home when someone's at home. So a good example, currently under the Clerks Award, you have obligations to work hours continuously. You can't split your shift and just go off and pick someone up and come back. You have minimum engagement provisions about each engagement needing to be a certain length of time. You have a variety of other provisions about span of hours. You can only work your ordinary hours 6 to 6. Now, if you are choosing to work from home and choosing that you would like to work differently, you might want to pick someone up in the afternoon from school. You might want to do some certain things at bedtime and then log on and do an extra hour. All of a sudden that imposes restrictions on the employer. They have to pay penalty rates, all sorts of things. So we're going to be seeking to liberate the Clerks Award in relation to working from home specifically, where an employee wants to do that. And that's what I suppose a number of kind of focus areas will be in relation to employers. On the other hand, from the union, we're likely to see an increased push to get a right to work from home in the award that goes somehow beyond the right that we currently have to flexible working arrangements. And that's really going to be heavily resisted, I suspect, because at the end of the day, traditionally...
Don't stress, it'll be heavily resisted.
Because the employer is the one that provides the work and provides the operation and the undertaking that generates the employment. The employer needs to structure its business the way it sees fit to ensure it runs well, efficiently, productively, and this notion that you can just change where you work at your own will, it sits pretty inconsistently with that. So that'll be fiercely contested.
What's the programming of that, just so
so
people
I think
understand?
Proposals are due with submissions in support March next year.
And if viewers want to really get involved and help out with that case, they can contact you directly?
Absolutely, contact me. I'm running it on behalf of Australian Business Industrial and Business New South Wales, and we're going to be putting both a very energetic program in terms of varying the award provisions that aren't well aligned.
So proactively in favour of employers when they permit this to occur.
That's right, enabling employers to permit this to occur and have award provisions that align with that. But equally, there's no way that I think we're going to consider it appropriate to just create a right to work from home because of the reasons I've said. So we'll be very keen to hear from businesses if that's the case. That's the big one. I'm going to very briefly also mention portable leave. If the government's re-elected, we're going to see that as the final area of our reform, I think, of substance. A lot more portable leave schemes, perhaps a national scheme whereby certain forms of leave can be carried across, whether that's sick leave, whether that's long service leave. We're seeing it in certain industries.
I know that people don't know what you're talking about because people with portable leave systems now know all this, but people who don't know what portable leave is, it's between employers.
Is essentially taking your leave from one employer to the other. Annual leave gets paid out, it's less of a concern. It's really sick leave and long service leave. So currently if you leave an employer, that's it. Your long service leave slate is wiped clean and you start again. In the construction industry, that's not the case. You can jump around
because we love making construction in this country so expensive.
Well, you can jump around in the construction industry and keep accruing your long service leave, and employers have to pay into a fund, which is quite expensive because if the employee was never going to hit 10 years, you don't have to pay. Whereas now you're paying to a fund, it's actually paying each month. We're now seeing portable leave schemes in New South Wales in the disability care area. And the federal government has indicated it wants to open this up much more broadly. And so you're going to find there is almost like a monthly tax on the business that it has to pay the leave into an independent scheme and doesn't arrange the accruals itself. And
so with annual leave and long service leave at the moment, that's a balance sheet provision. So you're taking money from your P&L into your balance sheet to make an accrual. The question there will be whether or not what you're currently accruing equates to what might be in one of these schemes, or whether
and it'll
it's more
definitely
expensive.
be less. It'll be what you're currently accruing
will be less.
is much less than
Sick
what
leave is highly problematic because it's not a balance sheet accrued at all. It's taken as cash off the P&L. If all of a sudden we're having to actually make a balance sheet accrual, that's a material cost impost on business that doesn't arise today.
I agree, but I think don't underestimate the first category, because if you just take New South Wales for an example, not only do you have a number of things that brought in, you can leave the industry for 4 years and come back and still accrue it. You've got a variety, and they're moving employers as well. What that all means is whatever you're accruing now, the rate's going to be much higher under the portable scheme, and it goes out every month.
Which is why I've got a lot of clients who are saying to us for the first time, it's actually not easy to do business in Australia. But we'll leave that. We'll leave that perhaps right to the end. I want to say wage theft. I want to say wage theft. January next year, the new laws kick in. This is a first in a national sense. It's not the first full stop, but it's the first in a national sense in terms of the Fair Work system. This is a situation where if you are deliberately not complying now with your obligations, you could face criminal sanction. You could go to jail. Look, you know my philosophical views on this. I think this is horrendous. 20 years ago, we didn't actually know what the word wage theft meant. My greatest concern at the moment, as I've gone around the country and talked to people about this, particularly in the last 6 months, is a lot of people haven't got ready for this in January next year. We've got a lot of clients who are doing wage audits and things like that right now. In fact, they're working very hard to sort of make sure they've got everything right. This isn't about just making a mistake. But the ones that bother me the most, and again, I'll come back to that small business conference I went to a couple of weeks ago. I had people in the room saying to me, yeah, but look, I've reached an agreement with my employee to do something different that's not in the award. Surely that's okay. And my answer to them was, no. There might be some level of mitigation if you're pleading that case, that, hey, the employee agreed to it. But that in itself is no defence. And you actually knowingly are actually not complying with your award obligation. So, bizarrely, I'm actually quite worried about how this might play out with, I'm going to use the word, smaller businesses, not necessarily small business, but smaller businesses it plays out. So that's the thing that scares me for the future.
This has got Julian very excited because he was running around 6 months ago about the technical breach, and effectively saying that there's lots of businesses out there that say, oh no, that's okay, we understand it's a technical breach, but we're doing something differently. Kind of comes out in the wash. Well, the problem with the whole technical breach thing now is if you knowingly are not complying, technical or not, it's a criminal offence.
I mean, if you're under what you're meant to be paying, and you might even got an advice to the effect of, look, you are in breach, but the risks of them bringing a claim, or the risks of, or they're as you say,
well, that world's changed.
They're kind of okay with it,
yeah.
Or they're a real loyal person who we've done plenty of things in the past for them. We'll be fine. You can't.
Yeah, I mean, is the ombudsman gonna, are all the inspectors gonna get in a car next year and race around the country and go to every restaurant and every cafe and every childcare centre and ask the question? No, but I just want people to be aware that this is just as of next year, this is going to be hanging over your head.
I think the big issue for HR operators, you're the ones in the gun, you're in the crosshairs, and it's really for you if you do uncover something. So you may not have known that your organisation's underpaying a particular area. That's fine, that's not criminal. But once you uncover it, then you're very much in the firing line.
And you can't say, let's leave it till next financial year.
This is the problem. You can't leave it unresolved. Once you've opened the bonnet.
If it hasn't been a problem for the last 4 years, we can kind of keep it the same, can't we? Like we can
Well,
just
let's
keep
wait till we renegotiate
All
the
of that
price agreement.
even though there was no intent to underpay, once you've discovered it, you've got to fix it, because if you don't, then you are as liable and as culpable as whoever put it in place to begin with.
I agree. So that's my big one. And then in the last couple of minutes, I'll probably just say this. Federal election in May, guys. If you'd have asked me the result a year ago, I'd have said Labor's going to romp in. I'm not a political person, you know that, although we sat with Michaelia Cash at a lunch last Friday that she came to for us. My sense at the moment is it's sort of hanging in the balance, because anything could happen in the next 3 or 4 months to change that, but it's hanging in the balance. But I don't think even if the coalition get in, I'm not sure they're winding all this back, even if they wanted to. I'm not sure they want to. They certainly want to make some important reforms to balance it up, but the challenge will always be the Senate.
So my take on this is the reforms are largely done. Even if Labor get re-elected, I don't think we will see a massive IR reform agenda. Certainly portable leave will be on the menu, but I think they've done a lot this term, and they've probably gotten that out of their system. They've given the union movement a lot of what it asked for. So we won't see a lot out of a Labor future government, and I suspect out of a future Liberal government, we still won't see much. We'll see the ABCC come back, and we'll see a little bit of touching up around the edges, but the key reforms, probably unlikely to go. So we need to start to work out how to manage with the existing regime we've got. There's going to be a lot more dealings with the Commission.
I think what might change though is some of these sort of sleeper, long game type reforms, like the changes to bargaining, we're never going to change things overnight.
But we might be able to change intractable bargaining, the one-sided arbitration.
That's possible, but I think in the next term of the government, whoever that is, we will see the types of things that we've said didn't happen this year. We didn't see these people being roped in. We didn't see all that. I think that has a prospect of gripping in the next election. Now, it will really depend who the government is, whether they say, good, that's what we wanted to do, or, geez, we have to do something about this. But it's going to be very interesting.
Well, as always, we'll come back after May and we'll let everybody know how it's gone. Thanks for being a wonderful audience this year. If you actually want sort of fine detail on anything we've talked about today, please go to the website. All of our alerts will take you through that. As always, drop us an email if you want to have a chat as well. It's been a very, very busy year. I think the whole team at ABLA probably deserve a break over Christmas. I'm not sure we'll necessarily get one, but we'll do our best. I hope your business has gone well for you this year. I hope you've managed to navigate the changes, and in some small way we've helped you do that. And please have a very, very safe Christmas and a very safe New Year. And I think we start up again in the new year, and we look forward to seeing you then. Julian, thank you for being here all year.
A pleasure.
Lou, thank you for being here as well. On behalf of the team, take care and be well, and we'll see you next year.